welcome to the Disability Law Show. John Scholes, Sivan, Tumarkin, James Fireman. You know the lineup here once again to talk about disability law and injury law and everything under that rather wide umbrella. Getting your learn on. A busy show today, by the way, guys. I want to talk about this in just a little bit, Sivan and James. 3 signs the insurance company may be about to deny your LTD claim. Maybe, which means they probably will be. The contact anytime, 1-855-821-5900, help@disabilityrights.ca. Before we move on, Sivan, to the week that was, something we want to talk about. I think we just introduced this recently on this show. Might have been last time we were on. If not, we're going to talk about it now. PocketEmploymentLawyer.ca. As the name would suggest, a lot about employment law and severance and workplace rights, all that stuff. But there's also a section there about disability law, which is nice because that was rolled into the website as well. So give me some details on how that portion works.
Absolutely, John. So we are disability lawyers, obviously, but at our firm we have lawyers who specialize, who focus on employment law. And so my partner, Lior Samfiru, came up with this new idea of creating the Pocket Employment Lawyer, hence PocketEmploymentLawyer.ca,
Yep.
where if you have an issue at your job with your employer, whether it's harassment, you've been let go, anything, you can go to that website and get really quick answers about your situation. But there's also a component there that deals with long-term disability. Because invariably, John, we get people every single week calling us who are on disability, are having issues with their insurance company. At the same time, they're having issue with their employer, and they need someone or some help with both issues. And so if you have an issue, not necessarily with your employment, but with your long-term disability claim, and instead of calling a lawyer or emailing a lawyer, for whatever reason, you just want to get the information right there and then, anonymously and for free, go to PocketEmploymentLawyer.ca. You key in a few pieces of information about your situation. Again, it's anonymous. You don't put in your name or your phone number, but it gives you a really quick analysis. You know, quick and dirty, you get the information you need as a starting point. And then if you want to reach out to us to talk about your particular case, we can certainly talk to you, again, for free, no obligation. But that tool, PocketEmploymentLawyer.ca, is just a fantastic new thing out there, first of its kind. And I'll tell you, John, it's been used extremely heavily across the country, not just in Ontario and BC.
PocketEmploymentLawyer.ca is the way to go. Check it out. Again, as Sivan says, it's free and it's absolutely it's anonymous. If you don't want anybody to know you were there, you can just enjoy it, use it, and there's also contact at the top and bottom as well if you want to reach out to the guys afterward. Okay, week that was. What do you got going on?
Again, John, tons of people contacting me every single week. And I want to tell you about this one lady, 42-year-old mother of 2, who had called me this week, literally crying on the phone because she got a denial letter from her insurance company. But it wasn't her first denial. It was actually a denial to the second time she had appealed that denial. So this is a lady who's been experiencing a lot of cognitive issues. She has memory loss. She has a lot of focus and concentration issues. But the problem is that the doctors that are treating her, and she's gone to a ton of doctors. She's even been in contact with doctors in the States, at Johns Hopkins University. No one can figure out what is going on, so they are running all these tests. At the same time, her treating doctors are treating her symptoms, but the insurance company has taken the position that because her condition hasn't yet been properly diagnosed or had been misdiagnosed in the past, therefore she doesn't qualify for long-term disability. And, you know, when I looked at her policy and I looked at denial letters, it was obvious to me that the insurance company is playing a game here. They're not supposed to deny someone because you don't know what the actual diagnosis is. We know that medicine has limits. We see cases all the time. Doctors will tell you, any doctor that you ever speak with will tell you medicine is limited in what we know and what we can do. So to deny her claim on the basis that they don't know what the actual diagnosis is, that they're still investigating, is inappropriate because no long-term disability policy out there requires you to have an actual diagnosis. The key is, or the question is, the test for getting LTD is, can you do your own occupation within the first 2 years? If you cannot do your own occupation and your doctors support you, and in this case, this lady's doctors unequivocally say that she cannot go back to her own occupation, she should be getting the LTD payments that she deserves under the policy. But we see this all the time. Insurance companies will take this position, and people assume that the insurance company is correct. They are not correct. I cannot deny your claim on the basis of the fact that the doctors haven't figured out the actual diagnosis.
James, you've said this a million times. It's not based on the diagnosis. It's based on the symptom.
Well, it's not me saying it. It's the Supreme Court of Canada, who happens to be a pretty good authority on the matter. So, yeah, the analysis is entirely on the symptoms. And if you are legitimately suffering from symptoms that are preventing you from being able to do your own occupation, you're entitled to your disability benefits. Whether or not medical science has advanced to the point that we're able to understand what the underlying cause is entirely irrelevant. That is not the analysis. Are you suffering from symptoms that prevent you from doing your job? That's it. It's nothing more complicated than that.
DisabilityRights.ca is the way to reach out. That is the website. You can find links to our radio show there as well. The email, just as simple, help@disabilityrights.ca. Guys, first email for the day. I want to read this to you and have you comment on it. This one comes from Ron. Ron says, my long-term disability was denied because the insurance company says that I don't have enough medical evidence to prove that I am totally disabled. I don't understand what that means. I'm 52 years old and have worked all my life in sales. I have MS, and it's been getting worse. My doctors wrote that I can't continue work because of my disease. How else can I prove my disability? What else do they need?
Well, Ron, I really appreciate the email. So first, let me start by disabusing you of the notion that you have to prove to your insurance company that you have a disability. You don't at this point. They already know it. This isn't about proving anything to them. You're not going to be able to do that. You have to understand that they have seen the medical evidence here. They understand what MS is. What they are doing is they are playing a game. They are betting on the fact that you're probably not going to challenge them. And that is what most people do. Most people will accept their decision. So don't believe that if you just get that one more doctor's report, that one other expert that can say, oh no, Ron really is disabled, that that's somehow going to change their mind. It won't. That's just not the way that it works. Now, the other thing I would like to comment on that Ron raised is he's not understanding what they mean when they say that he's not totally disabled. So I'm going to use air quotes. I don't like doing that, but totally disabled is a term that is invented by the disability insurance industry. And it is used as a way of suggesting to people that they're not entitled to benefits that they really are. Because when you hear the phrase totally disabled, it conjures up a meaning that has absolutely nothing to do with what is in the policy. What I mean by that is if you're talking to someone and you say, oh, I'm totally disabled, the expectation when someone says that, normal conversation, is they probably can't get out of bed. They probably can't do most things for themselves that people take for granted being able to do, getting dressed in the morning, feeding yourself, personal care type of activities. That's what people generally perceive the phrase totally disabled to mean. That is absolutely not what it means when we're talking about disability insurance. What it means is defined in the policy. Literally, if you were to look at your policy, there would be a page that has definitions. And one of those definitions is that term, totally disabled. And all it means is that you have a disability that prevents you from doing your occupation. It's only about whether or not you have a disability that prevents you from working. Has nothing to do with anything else in your life. Has nothing to do with being able to get up in the morning and dress yourself and drive yourself to and fro and to be able to do all of your chores and any other activities that you might have to do. It's just about whether you can work. That's it.
First of all, well played by the insurance industry for such a strong term.
Absolutely.
Right. Secondly, it must throw people off claim.
All the
not
time.
totally disabled.
All the time. All the time. And the other thing is that you see here in that email is that they told him he doesn't have enough medical evidence. You don't need 3 experts. You don't need a multitude of specialists to say that you can't work, or you can't do your own occupation or any occupation. You just need a doctor or a treating provider. I mean, obviously there's strength in numbers. So if you have a psychologist and a family doctor, an occupational therapist, and whoever else, if everyone is saying in writing that they believe that you can't do significant aspects of your job, well, then the insurance company has exactly what it needs to approve you. But even if you only have your family doctor, that is a starting point. Don't be dissuaded by that. I have people who say to me, I only have my family doctor and my chronic pain specialist who are saying I can't work. Do I need to go and get another opinion? No, you don't. You absolutely don't. That's sufficient. As long as they back you up, that is sufficient. And the insurance company knows it. That's what James is saying here, and it's true. They know it. They don't know that you know it now that you're watching the show. They assume that when they deny your claim on that basis, you will second-guess yourself and think, okay, well, maybe I don't have a case. Far from it. Yes, you do.
All right, guys, stick around. Coming up here, the 3 signs the insurance company may be about to deny your claim. Well, 3 signs. There's more than 3, but we're going to give you 3 after a short break. You want to reach out, 1-855-821-5900 and disabilityrights.ca. It's a disability law show. Don't go anywhere.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to the Disability Law Show. I'm John Scholes, Sivan, Tumarkin, James Fireman, answering your questions and emails and phone calls, 1-855-821-5900 to reach out when the show is not on, and help at disabilityrights.ca. But guys, as promised, I know you're anxious to, you're champing at the bit to answer these 3, and that is the 3 signs the insurance company may be about to deny your LTD claim. I don't know who's doing number 1, possibly both of you guys are. Number 1 is this: they've asked you to attend an assessment with one of their doctors or consultants.
Yeah, for sure, when I hear that, you know that it's just a matter of time before you're going to get that letter saying that they're cutting off your benefits. And the reason for that is very simple. Insurance companies are corporations, and corporations are there to make profits for their shareholders. That's fine, but you have to understand that is their motivation. And the way that they do that is by spending less money, and you do that by cutting off benefits as quickly as you can, and by spending less on each claimant that you possibly can. And so if the insurance company is taking a step where they are sending you to see a doctor for an assessment, that means they're spending money on your claim. And they're only going to do that if they see real value in it, and they're only going to see value in it if it means that it's going to be able to help them justify cutting you off in the future. That is what they are aiming to do with those assessments. They're not doing it out of the goodness of their heart, and they're certainly not doing it to help support you in bringing the claim. They're doing it for their own purposes. So when I see this, it's a red flag. You know right away you have to gear up because there's a fight coming, so you have to be prepared for it.
Do you have to go, Sivan?
You do.
You do?
You do. You have to go. But, you know, if people go to our website, disabilityrights.ca, you'll see past shows where we've talked about what do you do when you are being told to go to one of those assessments, because there are tips and strategies that you can use to your advantage to arm yourself and to prepare for these kinds of assessments. And what do you do before, what do you do during, and what do you do after? But yes, the answer is that you do have to go. Now, you don't have to go if every week they're sending you to a new assessor, right? I mean, there's a limit to what they can do. But generally speaking, if they want you to go see someone, then yes, you do have to go.
Now, I'll tell you something else about the assessments. You know, they're not always. Most often, you're going to see an assessor who knows who's paying the bills, and the reports are written accordingly.
Okay.
And very often, they're going to disagree with all the treating doctors and support the insurer's position. But not always. Not always. There are assessments that are done that are favorable to insureds, sometimes very favorable. But even in many of those cases where an insurance company will hire a doctor and send someone to see that doctor to provide them with a report, and the doctor comes back and says, no, this guy's really disabled, they still deny. They will cherry pick portions of the report. I've seen this happen. Not always, but I've definitely seen it happen numerous times, more than I can on one hand, I'll put it that way. They will cherry pick information out of the report and use that to suggest to the claimant that they're not disabled. So don't think that you're likely going to get a fair shake, either from the doctor or from the insurer when that happens.
But don't be threatened by it. Don't be threatened by that assessor if the assessor gives an opinion that's contrary to what your doctors are saying. One of the things that we do at the firm, and again, it speaks to the resources we have and the due diligence that we do on every case, every situation we represent an individual who's disabled, is as soon as we get this kind of an unfavorable assessment, we go through a legal database and actually put in the name of that doctor or consultant to see how judges have interpreted what they have said in cases that have gone all the way to trial. And in many instances, you start looking and seeing how judges have commented, you know, we don't believe this doctor, or this doctor doesn't have credibility. I mean, they won't say, you know, they won't speak in such stark terms necessarily, but they'll question the credibility of these assessors working for insurance companies because they're hired guns. So put those assessors versus your own treating doctors. If this ever went to court, which very rare for these cases to go to court, who do you think a judge will believe? And insurance companies know that.
Another sign, guys, that your insurance company may be about to deny your LTD claim is this. They suggested that maybe you should start a gradual return to work program.
So this happens quite a lot. And I have, both of us actually, don't have any issue with a person who is ready to go back to work, to try to go back to work, as long as they have medical clearance, they've spoken with their doctors, the doctors say, you're ready, you should go, you should try, you should be careful, but you should try, perhaps modified duties or modified hours or both. What I think is completely inappropriate is for the insurance company to pressure you to do that when you are not ready, and or if your doctors are saying that you are not ready, and you have zero obligation to try to go back to work if you are not ready. Because oftentimes, if your doctors say you can't go to work at this point, you're still disabled, still recovering, or if you feel that way, chances are, if you try to go back to work, your condition will become worse. And I tell you again, John, every week we speak with individuals who've been in that situation. But why do they try to go back to work despite the fact that the doctors are saying don't? Because the insurance company says, if you don't, we will cut off your payments. They can't do that. They do it, but they're not allowed to do that. First of all, it's unethical. And second of all, from our perspective, that's actually a breach of the contract, of the insurance contract. How can you tell that to an individual whose doctors are saying that person is still disabled? So, what is the remedy for that? The remedy is that you go to your doctor, you make sure you get, you know, an updated letter that says you cannot go back to work, you give that to your adjuster, and if they tell you that they're going to cut you off and they give you that cutoff date, you give us a call immediately. You email us immediately, and we'll tell you what you can do, because the insurance company cannot do that, and they know that they can't do that.
But James, if they're saying we're going to cut you off if you don't go back to work, if you do go back to work, they're going to cut you off anyway.
Yeah, once they, there are really three outcomes here, right? So they tell you they want you to do this gradual return to work.
Okay.
You say no, they cut you off.
Gotcha.
You say yes, and you're not able to do it. They say, oh, well, you should have been able to do it, and they cut you off. You say yes, and you are able to do it. Well, now you can work, so you don't get benefits anymore. They cut you off. One way or the other, once they insist on that, you're getting cut off your benefits. It's going to happen.
Can you try to go back to work? Can you take it for a spin? And what happens if, you know what, even against my doctor's orders or with my doctor's blessing, it turns out I'm not well enough to go back to work. I have to go back on claim. Can't you?
There's two answers to that question. So the policy says yes, you can.
Okay.
The policy in virtually every standard long-term disability policy will say that you can make an attempt to try and go back to work, and if you're not successful, as long as that period is less, and it's usually 6 months, something in that range, as long as it's less than 6 months and you remain disabled, you're entitled to resume your benefits without even having to start a new claim. So you wouldn't even have to go through the typical elimination period that you generally go through before you start your initial claim, which is great in theory. But in practice, in most cases, when someone tries to go back to work and they're not successful, the insurer just uses that as a basis for suggesting that they really are okay and they're just not trying hard enough.
You want to reach out anytime, by the way, 1-855-821-5900, help@disabilityrights.ca. Number 3 coming up here, the third sign. The insurance company may be about to deny your LTD claim, guys, is this one. They told you or suggested to you that they've checked your social media posts and or conducted surveillance on you. That scares people, man.
So
that scares people.
This is a big bugaboo of mine. And so if an insurance company is going to try and cut off your benefits because of social media or surveillance, I really want to know the specifics. Exactly what is it in the social media or surveillance that the insurance company believes is sufficient to deny or cut off benefits? That I would like to know, because in most cases, it's either completely irrelevant or, in many cases, it actually helps support the claim. So let's talk about that for a second. Social media. Now, let's talk about mental health issues. People with mental health issues, especially depression, depression. There's a perception that they walk around with a frown on their face all day long, but we know now that's just not true. That, you know, it doesn't mean that someone can't go out and have a good time with their friends and, you know, there's a picture of them smiling with their arm around their buddy. That doesn't mean that they're not suffering from depression. It means they had one good moment. It's a snapshot in time. That doesn't mean anything when you're talking about a disability. So if that's the basis that they're talking about, then I'd really like to know that. I'm not telling you that there's no way social media could defeat a claim. You know, if there's, you know, if you're saying that you have a physical disability and you can't get out of bed, and it shows you, you know, playing pickup basketball, you know, with your buddies, or, you know, going to work, in fact,
right.
Sure, okay, that's absolutely justified, but that's not what I'm talking about. Likewise with surveillance, it's the same thing. You know, surveillance, they will suggest to you that because you went out and ran an errand, all of a sudden you're able to work a 40-hour week. That's just not the way that it works. And it's even more true with surveillance that it can really work against them. Because what happens once we get the file, we're going to get all of the details about the surveillance, we're going to get the full report, and we're going to find out exactly how much surveillance was conducted. What time did the investigators start their surveillance at, and what time did they leave? How many days were they conducting the surveillance? So even if they have, over the course of, you know, 60 hours of surveillance, even if they have one or two moments where you're doing something active or that might suggest some ability to work, that doesn't mean that there's any ability to work over the course of an entire week.
Right.
And that's what we're really trying to get at. And so if they have, you know, 60 hours of surveillance, but you're only active and out of the house for 5 or 10 minutes, that's not going to hurt your claim. That supports your claim. That shows that you're really not doing much of anything. And that can really hurt the insurer. But guess what? When they get that the surveillance report from the investigator, they're just going to cherry pick out the little bits that work against you.
Because it's costing them money.
Yeah, that's right.
And they get something for it, right?
That's right. And they're going to be very vague in their report. They're going to say, well, we got surveillance, and it shows you with an activity level that suggests you're able to do your work.
Right.
That's absolutely untrue, and that's just not the way it works. If it went to court, they would lose on that.
Coming up, guys, dealing with an insurer who is ignoring your claim. We'll tackle that after a short break. 1-855-821-5900 and disabilityrights.ca. It's a disability law show. Still more to come. Don't go anywhere.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back to the Disability Law Show. Lots to get through in our last few minutes here, guys. Another option for you to reach out and ask questions is mydisabilityquestions.com. Simple. You go there, you can type your question. These guys, remember, the team will answer it, and you can actually search through the database there. There's a high probability that your question has been asked and answered in depth. So do that first. If not, leave it, and we'll get to it like we are about to now, guys. Jane, first one of the day from mydisabilityquestions.com. Jane says, my husband was on long-term disability for over a year, and then he tried to go back to work despite not getting the okay from his doctor, like we just spoke about. He tried to go back because the insurance company threatened that they would cut off his payments if he didn't go back. He really tried hard for several weeks, but was very ill, and his health was getting worse each day he was there. He was recovering from cancer treatments. I'm not sure what we can do. He's been at home for the last 3 months, and we haven't gotten any payments from the insurance company. They're simply ignoring him despite his doctor saying that he can't work. What do we do?
Extremely tragic situation, John, but something that, again, we see quite often, not necessarily with cancer, but with a whole myriad of conditions. So first of all, to Jane, very sorry that you and your husband are going through this. I mean, just the financial hardship that is created by this, John, it's unconscionable for the insurance company to do this, but they do it, and they do it all the time to different people. And Jane, the option is very, very simple, and we could have actually done that 3 months ago, which is to start a legal claim against the insurance company. Remember, when we get involved, the way that we change the equation or the power imbalance that you feel against the insurance company is that we start using the law. We use something that the insurance company now has to react to. Because, you know, when they deny your claim, when they tell you, we're not going to pay you anymore, usually they invite you to appeal that. In almost every letter that we have seen, in fact, in every letter that I have seen, where they deny your claim or cut off your benefits, they'll tell you you can appeal that. Of course, those appeals are useless because you have no leverage against the insurance company. You're basically re-asking them to reevaluate their decision. So what's their incentive to say yes? When we get in the picture, we do something that you, as an individual out there, as a layperson, you can't do, you don't know how to do, which is to use the legal process. Remember that we also used to work for insurance companies, so we were on the receiving end many, many years ago. We understand the power that the law has on insurance companies. Insurance companies are not above the law. And when we start that claim, I can tell you, in a case like this, with Jane's husband, John, we can resolve that claim very quickly. I've had cases where situations less serious than this, where we started our legal claim, and the week after we served on the insurance company the legal claim, and they appointed a defense lawyer to defend that, the lawyer called me. First thing he says, or she said, different situations, how can we resolve this case? You know, without prejudice. Basically what they're saying is, you know, we want a confidentiality agreement. We want you to your client to sign something. We'll pay. You know, so what does that tell you? It tells you that there are options. And Jane, there are options, and I suggest that we get in touch with you and your husband. We'll go through everything. You can do a whole show just on this case scenario, John. But there are options, and they're much simpler than people think. People have a lot more power than they actually believe, than insurance companies lead them to believe.
Well, you know, it's interesting because as soon as you bring a legal claim, there's something that fundamentally changes in the relationship. And this is something that you wouldn't understand unless you're doing this for a living, as we do. You know, as soon as you bring a legal claim, now you're taking the power away from the insurance company, so they don't get to control the entire process. That's number one. They know that if they're not reasonable, if they continue to be unreasonable, then at the end of the day, it winds up in court, and a judge is going to look at it, and they're going to lose. But it's not just about what they owe under the policy at that point. And if it were just about what they owed under the policy, it would get resolved very quickly. In fact, you probably wouldn't even have to bring the claim. But what happens is when we bring a claim, in almost all cases, we are going to ask for punitive damages. Now, sometimes it's not supported. Sometimes there is a basis, even if it's not ultimately justified. There's some basis for the insurer to take that position. But in so many cases, and I'd say far more than half of the cases that I see, there is real exposure on the insurance companies to punitive damages. In other words, there is a real chance that if the case ever went to trial, a judge would say, not only do you have to pay for the benefits that you should have been paying all along, but we're going to punish you by making you pay these punitive damages over and above what you owe for the benefits because of the way that you handled the claim, because you have failed to treat this claimant in good faith, as all insurance companies are required to do. And that is really important, because it's not just extra money potentially in your pocket, but from the insurance company's perspective, if it goes to court, that's a public decision, and that is a PR nightmare for them. They don't want anything to do with that. So yeah, as soon as you bring a claim, all of a sudden, they're very reasonable. They really would like to come to the table, and it happens very quickly.
It's amazing how fast they change their tune once you get involved, because otherwise they just string you along.
You know, they do,
and
John. And
else.
just before we run out of time, I can say that just on James's point about PR, because we've been in the media so much, not just on this show, but just in general. I mean, we've had high-profile cases. It is a nightmare for insurance companies. We know it's a nightmare for insurance companies because through the grapevine, we know some of the lawyers that work there, and they've told us that it's a nightmare for them. So not only are they losing on this case, but they're losing a lot more when other people hear that this is how they act. So you have a lot of leverage when you come to us because we have that ability to get this to the media if we want to, and of course if the client agrees. In most cases it doesn't happen. Insurance companies just want to try and settle with us.
Hope you learned a lot today. We will continue doing these shows for the next days, weeks, months, and hopefully years, and keep educating you indeed. You want to reach out now that we are done. Disabilityrights.ca is the website. You can find links to our radio show there as well. Email is simply help@disabilityrights.ca, and the phone number 1-855-821-5900. Remember, check it out, pocketemploymentlawyer.ca. There's a lot of employment, but there is a section pertaining to these guys when it comes to disability rights as well. So check it out, pocketemploymentlawyer.ca. Catch you next time, Disability Law Show. Appreciate it.